Alexis Naveen.
For the people.
Assistant Public Defender Hannah Apple appearing on behalf of Ms. Naveen. Ms. Naveen, can you please state your name for the record?
Alexis Naveen.
Your Honor, we have made some progress in our plea negotiations, but I would ask for another adjournment.
All right. No objection to that.
No, Your Honor, I do understand Ms. Burton Harris needs a bit more time.
Okay. Ms. Naveen, I always ask, how are you doing?
I'm doing okay, Your Honor.
All right, fantastic. February 6th, 2025, 9 a.m. Will that be enough time for you think?
Yes, Your Honor, I believe so.
Bond will continue. All right, thank you.
Thank you.
I don't feel like it.
Me either.
Court calls the case. People versus Rao Scott.
Individual is appearing on behalf of the people.
Who's this attorney?
Ms. Bashir.
Where's Ms. Bashir?
She's coming.
Oh, she's coming in with Mr. Scott or no?
Hi, this is Alexis Bashir. I'm on behalf of Mr. Monte Scott. He was here earlier.
Was he?
Yes, yes.
How'd that conversation go?
It went well, but I believe
Shocked.
if if I can have permission to check the hallway for him and delay call the case later.
She's so nice. Would you like me to pass it so you can find Mr. Scott?
Thank you, Your Honor.
All right. I'll pass it. Called him. Funny is, I called the name Feaster last. Court calls the case. People versus Antoine Patterson.
I can handle it. Yeah, that's fine.
Assistant Public Defender Jay Bellinger on behalf of Mr. Patterson, who approaches.
Look, your name?
Antoine Patterson.
Thank you, sir.
And Your Honor, we are asking to adjourn this matter 2 weeks so that I can complete a mitigation on Mr. Patterson's file.
Kennedy, did you put your appearance on or not?
I'm sorry.
You didn't? Oh, no, it's Bellinger's fault.
We have to work fast here. We know this.
No, but go ahead.
All right. Thank you.
Sorry.
Don't tell me.
I don't often apologize, so.
We know.
Wow.
Wow. Lots of love.
No, you guys go ahead. No. January 30th, 2025, 9 a.m.
Thank you. Thank you very much. I'll be in touch, okay?
Court calls the case People versus Michael Patterson.
After one of the people.
Assistant Public Defender.
if I say that really long, maybe he'll show.
Appearing on behalf of Mr. Michael Patterson, Your Honor. I do not believe Mr. Patterson, and I have not had contact with him. My understanding is that he was found to be incompetent. But restorable, I believe.
But restorable.
Yes, Judge.
Well, was there a report done?
Not that I'm aware of, Your Honor.
And my understanding was the last notice I had, the last correspondence rather, that I had from the Center for Forensic Psychiatry was December
Right.
9th, 2024, and it looks like he had failed to appear
Right. That's what I had.
at the examination.
Yeah. I don't have a finding. I don't have a report.
I may have missed something.
No, my notes in our file from my colleague who had the case said that he was found, but I don't have any evidence to support that. So that's just what the notes say, Your Honor.
I have no evidence to support what that attorney wrote.
Yes. Oh, obviously, I'll ask for an adjournment. But I don't know.
Yeah, I'll let you adjourn it, but I don't know that that's correct.
Okay.
I don't have a report.
Okay.
And Your Honor, just for the record, because he did fail to appear in his evaluation and he has not shown up today, people would request a bench warrant.
Yes. I think that's what I will do.
Fair enough.
Check into it. Bench warrant will issue for defendant's failure to appear. Bond $25,000 cash surety. That warrant will issue immediately.
Thank you very much, Judge.
Thank you. Court calls the case People versus Thomas Rivera.
Ashley Lonnie for the people.
Hearing to my right.
No, I just. Tomas Rivera.
All right. You're requesting an adjournment.
Yes, Your Honor. We are requesting adjournment for mitigation purposes.
For what?
For mitigation. He's working with our mitigation.
Oh, mitigation. I thought you said communication purposes. I
Sorry,
don't know what that is. How much, are they doing a report on?
they're
that?
going to do a report. He is going to meet with our specialist one more time after bringing some information to her, and then hopefully a letter will be written.
Can all that be accomplished in 3 weeks, you believe?
Supposed to be today.
He's going to meet with her today.
Okay.
So
All right, so
let's see if it, hopefully, Your Honor, we can get it done in 2 weeks.
probable cause conference. February 6, 2025, 9 a.m. Bond continues. Court calls the case People versus Patsy Shear.
Hello, Your Honor. Assistant Public Defender Chelsea Virgil is with and on behalf of Patsy Shear.
State your name, please.
Patsy Shear.
Thank you. All right.
Your Honor, we are ready to resolve this case with a plea, a no contest plea to misdemeanor domestic violence.
Oh, I'm just getting the papers now.
In exchange for the first charge being dismissed.
Correct, Your Honor. She'll be pleading no contest to count 2.
Gotcha. May I have her sworn?
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
State your name.
Patsy Shear.
All right. Ma'am, it is this court's understanding that you're going to plead no contest to the charge of domestic violence.
Yes.
That's a misdemeanor, punishable by up to 93 days in jail, $500 fine plus court costs. Do you understand that?
Yes.
Do you understand what a no contest plea is?
Yes.
All right. 2 things about it I have to make sure that you understand. It first of all means that you're not further desirous or wanted to contest this charge. You understand that?
Yes.
Second thing you need to understand is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that?
Yes.
You understand also, ma'am, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Freshour in the 14A4 District Court. You understand that?
Yes.
All right. Understanding all of that, you still wish to plead no contest.
Yes.
Counsel, the basis for the no contest plea.
Lack of recollection.
All right. To the charge of domestic violence, how do you plead?
Guilty.
All right.
No contest. Sorry.
No, that's not your fault. It's hers.
Sorry.
All right. You're pleading no contest?
Yes. No
All right.
contest.
And you understand that by pleading no contest, you'll not have a trial of any kind.
Yes.
You signed an advice of rights form. Is that correct?
Yes.
Any question regarding any of those rights?
No.
Please look at paragraph 5. Those are your rights which are part of a trial. You understand that by pleading no contest, you're giving up those rights as well as all the rights on that form.
Yes.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you
No.
to plead? Anybody threaten you or coerce you?
No.
You're doing this voluntarily
Yes.
and of your own free will.
Yes.
Court has been provided, is reviewing Saline Police Department report for their case number 24269. Any objections to the court reviewing that report?
No, thank you.
Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine a defendant's guilt of the defense counsel. Have I complied with the court rule?
Yes, Your Honor.
Defense is satisfied.
Court will accept the defendant's plea to count 2, count 1 is dismissed. Pre-sentence investigation and report is ordered at 14A4 probation. Sentencing in this matter will be
January 30th at 9:30 before just rush hour.
January 30th, 2025. I'm sorry,
9:30.
9:30
Your Honor,
for Judge Fresh Hour.
I'm sorry to interrupt. Her sentencing on her misdemeanor case that she pled to this morning, also before Judge Fresh Hour, is February 13th. Would we be able to get the same sentencing date for this case, the same type of case?
Oh. I think that if you contact Judge Fresh Hour, they may do that. However, you may not, only because this is going to go on a DV docket. And I don't know, is the other one a DV?
Yes.
Okay, I'll tell you what. This is the date they gave us, so I'm not going to change it. How well? Have a seat for a second. What's the date? What date did you have?
February 13th.
February 13th. Okay. Have a seat. I may change the sentencing date.
Thank you, Your Honor.
There next one. Check. I guess do that. Huh? Right, but they told us this. Yeah, just ask that. They gave us a date of 15.
Here, we were the 13th.
Yeah. Court does call the case of the people versus Christopher Shedd.
After a lot of the people.
Christopher Shedd.
Thank you.
At this time, Your Honor, we are requesting approximately a 1-month adjournment. Mr. Shedd does have a matter in 15th. And we are still waiting for some outstanding video discovery. So it's be about, we are seeking towards a possible global resolution. So this will allow for Mr. Shedd to have his court
next date in 15th
the 23rd
of this month.
of this month. Yes.
And you're waiting. Why would you need 4 weeks?
Just to allow us to confirm some other aspects of the misdemeanor of a potential global resolution that would allow Mr. Shedd to maintain his CPL. Will also allow me time to coordinate the other 8.
February 6th, 2024, 9 a.m. Bond continued.
Thank you, Your Honor.
You see, Mr. Shedd. Are you need 4 weeks? Court calls the case people versus Aaron Smith.
Andrew Childers appearing on behalf of the people.
Your name?
Aaron Smith.
Thank you.
At this time, Your Honor, I'll be requesting a brief adjournment. I was able to just share some information with with APA Childers, and we are working toward a possible resolution.
February 6th, 2024, 9 a.m. Bond continued.
Thank you, Your Honor.
25. I knew that. I wrote 25. Oh, I did. Huh? I knew you did rather than they. 25. Court calls the case of the people versus, is it Joe Smith or Javon Smith? Oh, it's broken. It's
Andrew Childers appearing.
Javon.
Assistant Public Defender Chinazi Carey. I can really, on behalf of Mr. Jovan Smith, who's approaching. Mr. Smith, state your name for the record when you reach the podium.
Jovan Smith.
Judge, we're requesting an adjournment in this matter. I think the last time councils were here, we requested an adjournment because of medical records.
Yes.
We received a notice from the hospital. They were requesting an additional 30 days to get those medical records together.
Yeah. Our office received it, I believe, on the 18th of December. And it was shared in discovery, but they were at that time requesting additional time to provide these medical records. I actually haven't seen this before, but.
So on the 18th, the hospital's requesting an additional month.
Right, so we're
right there.
around there. So we don't necessarily, I want to get the exact dates. So, So this was dated 12/18/2024. And they're basically citing HIPAA. We're exercising our ability under the act to execute a 30-day extension in order to comply with the request. This is in response to anarchy. These medical records. So I would expect some update in the next weeks, or perhaps
HIPAA. Okay. That means we don't have personnel to do this. Sorry. That may not be what it
Basically,
is.
right?
Okay. It's the holidays. All right. I'll give you an adjournment. So,
I mean, at least we have free healthcare. Oh, wait.
pardon?
Nothing.
All right. Why don't I try February 6th then? February 6th, 2025, 9 a.m. Bond continued.
Thank you. And
Oh, that sentencing.
That other sentencing is set for January 13th.
Oh, okay.
So
Oh, okay. All right. We call that back up. Court recalls the case of People versus Patsy Shear.
and then on behalf of people.
Assistant Public Defender Chelsea Vergils with and on behalf of Patsy Shear.
So you might want to check your other case that she has. Because you pled today on another case, right? Before Judge Freshour?
Yes.
And we were just informed that that was put on the 30th.
Okay, we'll ask to change both of them. Thank you.
All right, so I'm going to leave this as I said it, Bond will continue.
And may I address Bond, Your Honor?
Sure.
Thank you. At the risk of redundancy, I would ask for consensual contact. She has now been out of inpatient treatment for a couple weeks, I believe, and is.
What'd they do on her other case?
She said that right now she is not allowing consensual contact, but she said that she would consider changing it before her sentencing if you allowed consensual contact.
Who said that?
Judge Freshour. I also.
No, she didn't said that. Go ahead.
I also believe that the complaining witness is here today to ask for contact. Again, she's doing very well in her treatment and now resides at transitional housing, where she follows her other bond conditions successfully.
Your Honors, it was my understanding, or what I was told, is that Judge Freshour declined to address it until sentencing, so I'd ask that it remain in place until sentencing.
That sounds more like what I would think Judge Freshour would have said. Is that I can't see Judge Freshour having a DB, there being a DB hearing, saying, well, whatever the other judge does. I'm not.
That was my understanding, but I also
So here's what we'll
understand.
do. I'm going to deny your request to change that. And certainly, I'm sure Judge Freshour's next door. She'll be more than happy to hear you. I'm not changing it. It's all going to go before Judge Freshour. She can Render a decision on that. All right, thank you.
Thank you, Your Honor.
Court calls the case People versus Lamarck Stark.
Alexander, on behalf of people.
Ready, Judge. Court shall feature Assistant Public Defender on behalf of Mr. Starks. Mr. Starks will come forward and state your name for the record.
Mark Starks. Thank you.
Thank you, Judge. I have spoken to my client. He is asking that this matter be set for a preliminary. Hands on your pocket. This matter be set for a preliminary examination. I believe all discovery has been exchanged.
People have their witnesses available on the 28th.
Do our best, Your Honor.
Preliminary examination in person, January 28th, 2025. 9 a.m. before Judge Barr. Bond continue.
Thank you, Judge.
Thank you. Court calls the case, People versus Donald Taylor.
Assistant Public Defender Hannah Apple appearing on behalf of Mr. Taylor, but not with him, Your Honor. I did attempt to contact him. I was unsuccessful in that. However, my information is that he contacted our office this morning and he's currently hospitalized. Our staff did speak to a nurse to provide our fax information for verification. That fax has not come through as of now, but I would ask the court.
We received a message from, I think, him indicating he's in St. Joe's Hospital. He was advised at that time to let his public defender know, which sounds like he did, but you just haven't received verification of the hospital.
Yes, I will say our staff spoke with a nurse, so I know that he is there, but I don't have.
He's there, but you don't know.
No.
Much.
Nothing.
Being responsive to people.
He already got that for him as the rats.
Oh, he does.
Yes.
Here in office, we still have his community corrections warrant.
So what I'm gonna do is I'm gonna leave the warrant out. Well, here's what I'll do. I'll leave the warrant out. I will give another date, which sounds unusual, but I'll give another date for him to come back a couple weeks out.
Thank you.
January 30th, 2025, 9 a.m.
Thank you.
Calls case People versus Davion Thomas.
Andrew Childers appearing on behalf of people.
Assistant Public Defender Chinalda Kiriakin. Thomas was approaching. Mr. Thomas, state your name for the record, please.
Davion Thomas.
All right, you're attempting to do mitigation information.
That is correct, Your Honor.
February 6th. That enough time.
I don't think so. We have a little bit.
Is that just a feeling you have, or is there a reason?
It just
Doesn't
doesn't feel
feel
right.
like-
No, I think they're asking for about 6 weeks of mitigation, Your Honor. I think that's the last thing that I heard, but we'll work with the.
Who's that? Heard from who? The mitigation people?
We'll work with the 6th judge.
Well, I don't want to keep coming back and then, so I mean, I'll give a reasonable period in time, but it's the people in mitigation?
No, not necessarily them. Sometimes it's us, Your Honor. It's not, it's,
Why
I
would
don't know
it
my
be you?
sword. Reviewing it and then.
So, I don't know, but she made a
Accountability.
statement that seemed to throw other people in the office under the bus. So then she backtracked.
And I
And
fell on
said,
my
no,
own
they didn't
sword."
say that. And then she said, yeah, ow. Why don't I do this? Why don't I give them a month?
Thank you so much, Your Honor.
So,
That would be great.
February 13th, 2024,
Okay. All right.
25.
They'll be in touch with you.
I knew that.
You need a paper? February 3rd.
At 9, you know what? I don't hear it anymore. Fine, continue. Thank you. Court calls the case People versus Christopher Waldecker.
Andrew Childers appearing on behalf of people.
Assistant Public Defender Hannah Apple appearing on behalf of Mr. Waldecker, who's approaching now. Will you please state the record?
Christopher James Waldecker.
Thank you, sir.
We would ask for an adjournment for some continued plea negotiations.
This whole docket has been green sheet.
We're making progress.
You wouldn't know from today. How much more time did you need for these negotiations?
Talk to your officers, a couple weeks? 2 weeks, Your Honor.
Probable cause conference, January 30th, 2025, 9 a.m. Thank you. Bond continued.
Thank you.
Sir. This doesn't have a green sheet. I guess I'll do that. Court calls the case of the People versus Tiffany Simmons.
Good afternoon, Your Honor. May it please the Honorable Court, David Burgess on behalf of Tiffany Simmons, who's approaching.
Hi, I'm Tiffany Simmons, sir.
Thank you.
You're welcome.
Discovery is complete, Your Honor.
Thank you. Thank you for Mr. Burgess for actually calling my office, letting us know you were delayed.
Oh, no problem.
And telling us approximate time that you'd be here. That was very much appreciated.
And I think it was in like a minute. It was like not even lawyer time, Judge. It was actual.
I know it was actual time that
No.
you were giving. No, and we appreciate it.
No problem, Your Honor.
The court didn't get that same respect this morning.
Oh, I wasn't on your docket this morning.
I know. I'm particularly sensitive.
Uh,
All right.
Um,
So you guys are ready for exam.
thank you, Judge.
People have their witnesses available on the 28th.
We'll do our best, Your Honor.
Preliminary examination in person, January 28th, 2025, 9 a.m. before Judge Washington.
Thank you, Your Honor.
Thank you. Bond continued. Thank you, Ms. Simmons. Court calls the case People versus Aaron Washington.
Assistant Public Defender Hannah Apple appearing on behalf of Mr. Washington. Will you please state your name for the record?
Aaron Washington. Thank you. Good afternoon. Good afternoon, sir. You're requesting an adjournment.
Please, Your Honor.
Okay. Where are those other things in process, do you know, and how long?
Did you get my message? Okay.
No, I don't think so.
Okay.
I probably did. I did not read.
Okay.
Wow.
Been waiting on my office to review a new case for Mr. Washington. I've been waiting for the police to submit it. Finally, today I found out it's actually not our case. It's the township prosecutor's case, and it's under review there. So I
Cannot say how long. Got it.
I'll sit down.
All right. But you still may want to try to wrap it into whatever you're,
Ideally, yes.
all right. Let's go to February 13th, 2025, 9 a.m. Bond continued.
Judge, I'm sorry, I missed that date.
13th.
13th. Thank you.
Yeah. Oh, I was talking to you. I'm
13th.
sorry. Okay. Thanks, sir.
13th.
Court does call the case People versus Hannah Wellman.
Andrew Childers appearing on behalf of people.
Ashley Moten, Assistant Public Defender, appearing on behalf of Ms. Wellman. State your name. Sit right here.
Hannah Wellman.
All right, this is a waiver.
Yes.
Ms. Wellman, you're going to waive your right to a preliminary examination?
Yes.
You understand that that's a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it?
Yes.
You understand you'll not have that hearing and that you'll proceed to circuit court for further resolution.
Yes.
All right. People also waive their right.
Yes, Your Honor.
Preliminary examination having been waived, defendant is bound over to circuit court on a single count.
I will waive formal reading of the information and stand mute.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea. Pretrial will be set for
March 12th at 1:30 before Judge Conlon.
March 12th, 2025, 1:30, Judge Conlon.
Okay, thank you.
Bond will continue in this matter. Court calls case People versus Madison Welson.
And on behalf of Mr. Welson, who's appearing to my right. Please state your name for the record.
Madison Wilson.
Andrew Childers appearing on behalf of the people.
At this time, we would like to ask for a 30-day adjournment, Your Honor,
Why?
seeking mitigation information,
That's not what this is.
proof of treatment.
So is he in treatment now?
He is, Your Honor, and we're just
All right,
waiting.
you're just looking for time to see
Yes, Your
how
Honor.
he's. That's what you meant to say.
Yes, that's what I said.
Wow. She wouldn't listen to how. No, she says exactly what's on her mind. It's gonna get her in trouble, but she says what's on her mind. All right. So how far along are you in treatment? How long have you been in?
I want to say the week after I got out of jail, I enrolled in IHA Medical.
Okay.
Program. I'm in that. I'm attending AA meetings, paying my supervision fees. So I'm pretty sure I've been in there this whole time.
Okay.
My scripts every month.
Got it.
I see my doctor once a month.
Once a month? Okay. So why don't we do this? Let's,
And I do drug tests with her also.
pardon?
I drug test with her also.
Her
On
also.
top of community corrections.
All right. Probable cause conference, February 20th, 2025, 9 a.m. Okay.
Thank you, Your Honor.
All right. Good luck to you, sir. Court calls case People versus Ryan Wheeler.
Ashley Lonnie for the people.
Hannah Mack on behalf of Mr. Wheeler, who's appearing to my right. Please state your name for the record.
Ryan Wheeler. All right. And of course you are. This is just for straight plea negotiation. Probable cause conference without objection, will be adjourned January 30th, 2025, 9 a.m. Bond continue.
Thank you, Your Honor.
What time?
9 a.m.
Okay. 1:30. Okay, thank you.
Have a
Court-
good day, Your Honor.
Is that it for you?
I think you're coming to my school tomorrow, though.
Coupon shoe.
I thought
Oh.
you were a fan of my school.
Oh, so hold it. I am. But I thought I was supposed to be giving an oath. You haven't taken the oath?
No, not for me, for my friends were telling me that you were coming to the court, to our school.
Oh. You won't be? Okay, then I'm going. No. Court calls the case for the People versus Edward White.
Public Defender Federal Nicholas Berkovich on behalf of Mr. White. Mr. White, can you state your name for the record?
White.
At this time, Your Honor, we'll be setting this matter for a preliminary exam. To my knowledge, all discovery is complete.
People have their witnesses available the 28th. Preliminary examination in person, January 28th, 2025, 9 a.m. before Judge Barr. Court does call the case People versus Ernest Zizar.
Assistant Public Defender Asli Bashir on behalf of Mr. Zazar.
Ernest Zazar.
Cesar. All
How you
right,
doing, man?
I'm doing great. Thank you.
Uh,
All right, what are we doing?
We request an adjournment for further negotiations with the prosecutor.
Probable cause conference will be adjourned January 30th, 2024, 9 a.m.
Oh, Your Honor, if we could request a longer adjournment, we also need to collect some mitigation information. So would it be possible to request an adjournment of
6 weeks?
or 4 weeks? We could do
6 weeks?
uh,
Is that what she said? She said 6 weeks?
Alternatively,
6 weeks.
Your Honor, I believe.
Who told you to ask for 6 weeks? See, Akinruli said some things. So why are you requesting 6 weeks?
It was a determination based on my own judgment, but I would defer, of course, to Your Honor, as it's your decision.
That was at Yale speak. February 13th, 2025, 9 a.m.
Thank you, Your Honor.
You and Akinruli are up to something.
Nope.
Oh, no.
No, you
Not you. You're good.
This is
No.
all on me. This is all. on
What?
me.
No, it was not all you. Akinruli's doing something. I don't know what it is. Court calls the case, People versus Eric Simmett.
And then on behalf of the people.
Good afternoon, Your Honor. Deborah Schlossel on behalf of the defendant, Mr. Eric Sibbett, who is approaching police station.
Eric Simmett. All right, good afternoon. All right, what are we doing?
Your Honor, I am freshly new to the case, so I am asking that we adjourn this matter a few weeks so I can get discovery and go over it with my client.
January 30th, 2025, 9 a.m. Bond will continue. Thank you, sir.
Thank you. Your Honor.
I don't think I've seen you, counsel, so Happy New Year.
Well, thank you. Happy New Year. You know what, Your Honor, may I ask, is it possible to ask on the record to do Zoom?
Sure, you can ask. I don't have an answer.
Okay.
You can submit the form.
I'll-
Thank you. Court recalls the case, People versus Rao Scott. There he is.
So this is on behalf of the people.
Assistant Public Defender Asli Bashir on behalf of Mr. Scott
Rao Scott.
or Ante Scott.
Thank you. All right. You're requesting a 2-week adjournment?
Yes, sir. For further negotiation.
That objection, probable cause conference will be adjourned January 30th.
January 30th?
Yeah.
I got a dentist appointment on that day. I gotta go get my teeth fixed.
Um,
My tooth fell out.
Oh, I'm sorry.
When I was drinking a Vernus, it fell out.
When you were what?
Drinking a Vernus, it fell out. Remember, it was loose last year.
Oh, yeah, I remember. All right, let's go. So you'll be good in a week after that?
Yeah. Yes, sir.
All right. So what we'll do is we'll set it for February 6th, 2025, 9 a.m. Okay, so the following week after, Mr. Scott.
Thank you, Your Honor. And also, I'd like to correct my statement. The reason for the adjournment is to advise my client on the outcome of negotiations, not for further ones.
Gotcha. Okay. All right. Take care, Mr. Scott. Okay. Counsel, were you aware of others that?
There are co-defendants, but not on this complaint. I don't know why not. But I just spoke with the AG.
Yes, we're talking on the Lewis matter. And I think, Madam Attorney General, you were here.
Yes, Your Honor. Benita Hoffman on behalf of the people. I'm an Assistant Attorney General, and I have spoken with opposing counsel regarding this. There are 2 co-defendants. One is Alice Elliott. She's also charged with a felony. And then the other one, Josiah Walker, is charged with a misdemeanor. And those are scheduled, I believe Alice Elliott is scheduled for arraignment next week, Your Honor.
Okay, so do you see that one?
I see that the file went to magistrate, I think on the 16th. I don't show that an arraignment was set in January. It's possible. to do that. I can confirm what they're saying.
Pardon?
I can try to confirm what they're saying.
Hold on,
No, wait,
hold on.
just wait a second.
Hold on 1 second.
Seeing if any of those folks were actually here, we could arraign them right now, but they're not here.
Well, part of what I'm concerned about is how these got separated in some respect, but I think I know how that happened, because I think one was flagged for whatever reason as a potential bond violation, and why it then came to me, but then determined not to be.
Correct.
And then, what are you looking?
It looks like Miss Alice Elliott is represented by an attorney who filed a bench warrant recall form on her behalf. The magistrate's office is trying to arraign them by Zoom
Tomorrow. Okay. And that's a felony charge.
Yes, I'm listening to you.
That was a misdemeanor complaint, so likely that's gonna go to 15. So I got enough problems here. I'm not gonna deal with that. Okay. So what date? Well, the prelims are on February 12th. Okay. All right, we'll get to that at some point. All right, court does call the case of the people of the state of Michigan versus Samantha Lewis.
Good afternoon, Your Honor. Benita Hoffman, Assistant Attorney General on behalf of the people.
Thank you. Good afternoon, Your Honor. Good afternoon to your staff. My name is Amir Macklett. I represent Ms. Samantha Lewis, who's president, standing to my right.
State your name, please.
Samantha Lewis.
Thank you. All right. This is an arraignment on 2 charges. One, resisting and obstructing and assaulting a police officer, and a charge of carry along of trespass. Counsel, do you wish a formal reading of the complaint, or do you?
Thank you. Respectfully, Judge, I'd ask the court to waive the formal reading of the complaint. Ms. Lewis understands the charges before her and will stand mute to both counts.
All right, defendant having waived formal reading, standing mute, court will enter a not guilty plea as to both counts. I will set this for a probable cause conference, and typically, as you know, our practice, we set the probable cause conference and then the exam comes along, so I won't be giving you an exam date. But I guess here's my question. I currently have the other matters that are set for exam February 12th, correct?
That's correct.
All right. So is this going to be something that is separate from those? Or
yes, they're different days.
Yes.
It's a different protest. So different facts, different witnesses.
Different days. Okay.
It's still the same, essentially the same witnesses. It's the U of M police department, but yeah, there are separate facts and separate dates.
Separate officers even.
There? I don't know. Oh, well, here's what I was just trying to figure out. Does it make sense to set this for, I'll set it for a PCC, but is this going to, is it likely that this would end up on the 12th or not?
I don't think we'll have an exam on the 12th for this particular case, not with as many co-defendants as we have on the other case. I think that exam will run for, quite a while, just because there's 5 or 6 co-defendants.
I'm aware, okay, but what I'm saying is, is it going to make sense because of the nature of the activities to put them all together? I'm not so much concerned about the witnesses, but one of the things I'm concerned about is Miss Lewis coming here. She'd have to come for a PCC on this, then come back for the exam on the other matter. And I just, I'm just looking to try to make it as convenient as I can for everyone, but if nobody
We could
wants to
set the
do that, I
PCC on the
won't.
12th.
Pardon?
We'll waive the 21-day rule, set the PCC on the 12th. That way the other.
That's a special date that I've set for the exam. Because I've got, I think, 8 co-defendants, so.
I'm at your discretion, Your Honor.
Well, I can just set this in the normal course, but I don't know if that inconveniences everyone in terms of doing it. That's all I was trying to do. I mean, I don't have to try to be nice about it, but I'm
If
trying.
we could set it, let's keep the 12th date if we can, Judge. I think that helps because I know my calendar is clear on the 12th. I know.
Well, the 12th will happen.
Right.
Where do you want me to put this case? That's what I'm asking.
We could, if it's the same witnesses, let's put it on the 12th, maybe right after.
For an exam, or you want a PCC before it and then make a determination as to we put it to the 12th?
Sure.
Would that make sense, Madam Attorney General?
Yes, I think that's fine.
All right, so what I'll do is I'll just set a probable cause conference in this case I can do a probable cause next week on the 23rd if that works.
If we can have it in the afternoon, it would work for me, Judge.
If you'll give me one moment, I'll check my schedule, Your Honor.
Okay. I'm here all day, so I'm good.
Yes, the 23rd. I have a
Well-
sentencing in 15th District Court at 2 p.m.
They'll wait. No, I'm kidding. Okay, you have a sentencing at 2 in the afternoon at 15 on that.
Yes, in front of Judge Valvo.
Got it.
It's on another defendant. No, not a co-defendant, excuse me, another protester.
Another. Got it. And you need the afternoon.
That's correct.
We have a 12:30 block. Yeah. Okay. Then, okay, here's what I'll do then. I'll set a probable cause conference for January 23rd, 2025 at 12:30. Timelines having been waived, then we'll figure out, after looking at everything, where this one will go from there. All right. Any issues regarding bond on this case?
Your Honor, with respect to bond, we are asking that you not have any contact with the University of Michigan's properties or any of the University of Michigan property or students except as necessary for medical care. We're asking that you refrain from any assaultive conduct. We're asking that you not have any contact with the Tahrir Coalition, which is an organization.
I'm sorry.
Tahrir, Tahrir Coalition.
Okay.
And that she not have any contact with Alice Elliott or Josiah Walker.
Assuming a recommendation of PR bond.
Oh, yes, that's fine.
And it's Josiah, you said Walker?
Yes, Your Honor.
Counsel, any
Yes.
response to the condition request?
We don't object to personal recognizance bond, Judge. Ms. Lewis obviously has ties to the community and substantial support as evidence in the courtroom. I do have a strong objection to any prior restraint to this coalition or organizing or being a member or associated with the Tahrir Coalition. I don't know what the Tahrir Coalition is. It, according to the Attorney General in my conversation with her, she says it's a group that protests. Well, I don't think that the court rule 6.106 has any condition that would impose a prior restraint when it comes to bond. It's a
that's not true, counsel. I mean, I heard this argument when I was reviewing the bond. Many times bond is about prior restraint, if you're gonna look at the definition of prior restraint. So I mean, I don't know that that is a compelling argument for the court.
Well, I think the association it's another right that an individual has, a citizen has the right to associate, to organize, and to have a meetings with other individuals. This coalition, whatever the coalition stands for, does, or whatever activity they do, I don't think it's necessary as a condition of her bond. I think that it becomes an imposition that is not, it's a set of standards that doesn't happen in any other case. This is a situation, it's not part of her bond condition in the other case that we have pending before this court. I don't have an objection to not going to the University of Michigan except for medical purposes. No problem there.
Let me just ask this. Is she a student at the university?
No, not currently.
Okay. So let me also then, I guess, ask the question, would there be any reason, so there's no reason that she would need to go to the University of Michigan except if it were
for medical
purposes along those lines, right?
Correct. That's correct.
Okay. I see that her address is a Detroit address. Is that?
That's correct.
That's correct. Okay. So is there any reason that she would need to be in Washtenaw County? And I'll tell you why I'm asking that. It may seem broad, but I also don't believe in placing individuals in positions where they may violate a condition of bond and not now. If it were easy, even for those of us that reside in this county, to figure out exactly where University of Michigan property is, then I wouldn't have a problem. But you could be walking along and all of a sudden she could find herself on U of M property, not necessarily meaning to, but then in at least technical language violating the bond condition. So I try to set parameters that may seem rather restrictive, but also are clear for defendants. And one of the other things certainly let you talk. The other thing is I could not do, for example, I can't say Ann Arbor because University of Michigan properties exist within Washtenaw County, outside of the city of Ann Arbor.
Well, Judge, there's campuses in Flint, there's campuses in Dearborn. There's.
No, I know, but I'm more worried about here right now. I can't. My wonderful colleagues around the state can worry about those other places. I just have to worry about here. So,
Judge, she has ties to Washtenaw County. If the court's thinking about imposing that, she does have ties to Washtenaw. So I don't know where the court would like to go in terms of imposing a no contact order with the county of Washtenaw. She has ties here. Familial ties, personal ties, friendship ties, work associated ties.
All right, there's going to have to be some information given to the court about this. Is it Tahir Coalition?
So
I don't. Go ahead.
The information that we have in our files is that the Tahir Coalition is a professional organizing group that advocates for pro-Palestinian policies. And we don't have a problem with the fact that it exists or that it advocates, but Ms. Lewis's involvement with that group has so far resulted in 2 arrests for her that have resulted in charges for resisting and opposing a police officer. And for that reason, we're concerned about the contact that she has with them and the work that she does on their behalf, because it is leading to that kind of assaultive behavior.
But are you indicating that her connection to the group, that she somehow is causing others in the group to act in a certain way, or that by her being part of the group, she's now acting in a certain way? I guess I'm unclear as to that.
Sure, Your Honor. I don't know if the group is causing her or if she's causing the members of the group to behave the way that they're behaving. But at the last case, the juvenile was arrested for resisting and opposing as well. We elected not to charge her, but there was a juvenile that was involved in this particular protest. She was sort of the ringleader. She was the one that had the loudspeaker. She spoke over the officer who was trying to get the people to disperse and put down signs that they had pointed edges on the sticks. And then she resisted the police officers when they went to arrest her. So our position on it is I don't know if she's the cause or if she's caused, but either way, she's behaving inappropriately. If she was just speaking, no problem.
Right, but outside of the behavior that different sides may disagree on, I'm trying to figure out what the correlation is between the behavior that is alleged and her participation or alleged participation with this group or coalition. I'm not following it, I guess.
Your Honor, I understand the court's concerns, and in light of the fact that she could do work with the organization, I would rephrase my request to be that she not be involved in any protests with the organization.
Gotcha. Judge, we're not coming to camp.
Hold on before you go, because I'm sure you've got a lot to say on that.
I do.
Yeah. Well, again, maybe you have to help me here. Is it this To Hear coalition that is responsible for the protest? Is that the piece I'm missing?
That's what we believe to be the case, Your Honor.
Okay. And so, again, so that I'm clear, that the To Hear coalition is alleged, or at least thought to be responsible for the protest. And so you want to restrict this individual's participation with that group because of their responsibility for organizing the protests that have led to this.
That's correct.
Okay. All right. At least understand their position. Maybe I agree, don't agree, but go ahead.
Very well. Thank you, Judge. Respectfully. The defense, and the court is no surprise, the defense is this is free speech, that these are protests, and that this is indicated that she's presumed innocent until proven guilty from the very outrageous, ridiculous, and with no merit to the charges that she's brought now twice. Okay, this is going to be very litigated. Her position is that she's not guilty and that she's going to be presumed innocent until proven guilty. The bond conditions, Judge, are supposed to be set so that somebody comes before this court and that there's community safety and other provisions that we've already accomplished one provision of safety for the community. She's not going back to campus. Nothing associated with the University of Michigan. We agree. The further condition of association with Tahrir Coalition, whether or not they're the reason for this group that organized this protest or not, that's, to me, I don't think that they are. I think that the reason why these protests occurred is because the genocide that was happening in Gaza. So whether it's Tahrir organization, Students for Justice in Palestine, any other of the dozens and dozens of groups that are standing and against what the purpose of that protest, they could have been associated with as well, with these protests. You can't just pick one group and say, you can't be a part of that because we believe with no evidence. It's just it's a summarily stated statement by the AG at this point that she can't associate with it. It doesn't have any reason or purpose in a bond condition. It's not necessary. We're not going to campus. We're not going to have any more protests. She's not protesting. There's a ceasefire, thankfully, that we've heard of. So I think that the situation has calmed down a bit. However, it's unnecessary at this point, Judge. And 6.106 it's not required. When we get to the other issues of no contact with the co-defendants, Judge, we have joint defense agreements in this case, in the other case. I don't know if we're going to do the same in this case, but the lawyers will be communicating. And there is going to be time when our clients are going to be in rooms with the co-defendants while we're communicating defense in this case. I'm letting the court know that from now. We've been in talks, and we're going to continue to talk to defend our clients. So outside of that, no problem. We're not going to have contact. But I just want to make the court aware that there are joint defenses in this case.
I understand that, and I don't think that court's order would in any way be interpreted to cover the scenario that you're indicating.
Thank you, Judge.
I mean, I don't think it could. So that's the first part of that. The other part, though, is anything else from either side?
Your Honor, I didn't hear the last thing that the court said. I'm sorry.
I said, was there anything else from either side?
No, Your Honor.
All right. I will indicate that I'll set the defendant's bond at a $10,000 personal or cognizance bond. She's not to leave the state of Michigan without permission of the court. She's not to commit any crimes, she is not to commit any crimes. She's immediately notify the court of any change of address. She is not to use any illegal substances. She is not to purchase, possess, or any firearms, ammunition, or anything fashioned to be a weapon. I think that it's too broad regarding the request. Well, there are two real issues here. One being the To Hear Coalition. Without more, this court would have some concern with restricting someone from talking to a particular group. I am not familiar with the To Hear Coalition. But if, for example, that coalition, and again, I don't know, if they have certain different arms of that coalition that do different things, and she might be involved with the humanitarian effort within that, and it would seem improper for the court to stop her from being able to engage in that. So, so without knowing more, I am going to decline to put a prohibition on the defendant that she could not have contact with the To Hear Coalition. By the same token, as I kind of was signaling and would indicate, that except for court-related proceedings and other things, I am going to indicate that the defendant is not to be in Washtenaw County. I don't see a basis or need for her to be here. If she has to visit friends, she has to make certain other arrangements. That will, counsel, you may want to, counsel, you may want to mute when you if she's stuck. I just wanted to.
I'm sorry.
Go ahead. You can finish your question.
Judge, I need to approach, but I don't know how we're going to accomplish that with the AG on Zoom.
Because I'm the master of Zoom, and we will.
If I may approach, Your Honor.
Pardon? Oh, you need to let go. Oh.
I did. I just let go. I need to approach. Just.
All right. Here's what we'll do.